NACDL is the association of the nation's criminal defense bar.
Hello, my name is Vanessa Antone. I'm Senior Resource Counsel for NACDL, and I'd like to welcome you to today's webinar, Digital Defense in the Post-Dobbs World. As with all webinars, we would like to remind you to submit your questions through the Q&A function. With the chat function in this webinar, you're also going to be able to get some links to some things that the panelists are going to discuss today. And that is also where you can submit some technical questions and anything else you have for me. But submit your questions through the Q&A because we want this to be as interactive as possible with our panelists today. NACDL is presenting many trainings on defending pregnancy-related prosecutions, this being one of the new series, and another one in the upcoming series will be held on December 2nd. That is Conspiracy, RICO, and Accomplice Liability in the Post-Dobbs World. If you have not yet registered for that, you can go ahead and do so. We also have a few other events that are special events that are scheduled that are also on defending pregnancy-related prosecutions, including a public defense summit that is coming up on November 10th, which is an event not just for public defenders, but it does include those folks, but also lawyers who do court-appointed cases, CJA cases, and everyone who does public defense work in that community. So if you haven't already registered for the Public Defense Summit, please check our website and do that. Lastly, for now at least, we also have an in-person event coming up on December 16th at George Washington University in Washington, D.C., and that is our National Summit on the Criminalization of Reproductive Health Care, Defending Cases After Dobbs. So if you are interested in that, please check our website or contact me for an invitation to that limited space event. We are proud to be able to present these thanks to funding we have, and we would like to acknowledge the Evelyn D. Reamer Funds and everyone who has donated through NACDL's Foundation for Criminal Justice to support this work. So without further ado about the boring things, we will get rolling with the exciting content. And to kick us off, I would like to introduce you all to Jumana Musa, the director of NACDL's Fourth Amendment Center, who is going to introduce the rest of our speakers today and tell you a little bit about the work of the center. Thank you, Jumana.
Thanks, Vanessa, and welcome everybody. We're really glad you're able to join us today as we start to discuss the digital divide and essentially how that's going to impact the way this wave of criminalization that is coming, whether it's pregnancy-related crimes, reproductive healthcare-related crimes, all the criminalization that's coming in this post-Dobbs era. We at the Fourth Amendment Center, of course, do not focus on this work. My colleague Vanessa does a fine job of focusing on the work of the wave of criminalization that is coming in a post-Roe era. We, on the other hand, focus on all the technological ways in which police are able to track down and use people's digital lives against them. And so when we go forward today, we're going to talk about a few of those ways and how we think they may intersect with the prosecution of pregnancy-related crimes or the criminalization of reproductive health care. And I want everyone to understand that this is, it's sort of like going to a restaurant and ordering a sampler, right? You're not going to get a full meal on any one of these topics. We do have trainings online if you want to go in depth on any one of these topics we'll be covering, which of course are device searches, reverse search warrants, and face recognition. But for today, you're going to get sort of the high level, the highlights. And we also will be happy to come back and do any trainings that are requested of us. So just keeping that in mind. I will also say that there are times as we talk about the various types of criminal statutes that are coming into play in this post-Dobbs era, where people will refer to the criminalization being centered around women. We also acknowledge, though, that many people can get pregnant, whether they are intersex, gender nonconforming, transgender. Our intent, of course, is to reference anybody who can be targeted with one of these criminalization statutes. So again, pregnancy-related crimes, whether they're doctors, whether they're nurses, or however they identify themselves. And so we fully recognize that this impacts more than women. Lastly, I will say that we are very much enthusiastic about partnering, not just obviously with our anti-CDL partners who do other parts of the work, but with any of you in terms of looking at how this will impact criminal cases going forward. We have on our staff deep expertise on these digital questions that we are ready and willing to share. And so with that, I will let you know that we are going to hold questions until the end, unless you have a very pressing question that will keep you from understanding the rest of the presentation as it moves forward. I welcome you to put any questions in the Q&A and we will ask them at the end. I will be moderating the Q&A session. And in addition, for your CLE credit, you will get a code towards the end of the presentation. And so you'll have to stay with us and hear everything that happens between now and then. As far as introducing the folks who will be presenting to you, I'm not going to introduce them all at once. I'm going to go sort of person by person as they present. And so we're going to start our presentation with Sidney Thaxter. He is senior litigator at the Fourth Amendment Center. He spent 12 years at the Bronx Defenders before coming to NACDL, where he not only carried a caseload, but he also started their digital forensics unit, has deep expertise in defending device search cases, and is going to share some of that expertise with you. Sid, I'm happy to turn it over.
Thank you, Jimena. Appreciate it. So we're going to start with a discussion about Fourth Amendment challenges to device and account searches, because we think those are going to be the types of searches that you're most likely to see in abortion-related prosecutions. The reasons for this is that the contents of online accounts and devices they're incredibly effective evidence. Generally, in these types of cases charging people with crimes related to pregnancy or abortion, the prosecution relies on circumstantial medical evidence to show things like intent. But with device and account searches, they can actually demonstrate what a person was thinking through their browser histories, their search histories, or text chains with loved ones. That's why this data has been referred to as a window into the soul. We've also already seen this type of evidence leveraged in criminal cases charging women with crimes related to their pregnancies. And so I want to start by just highlighting a few of those cases we've already seen in the past. In 2013, Purvi Patel was prosecuted for feticide and neglect for allegedly ending her pregnancy through the use of abortion medication. And the prosecution's evidence included extensive amounts of text messages between Ms. Patel and a friend discussing obtaining and using abortion pills. There was also a search of her apartment that recovered an iPad with a customer service email from a website that sold abortion drugs without requiring a prescription. Another case from Mississippi in 2017 involved a woman, Letice Fisher. Her husband called 911 to report that she had given birth in the home. And when EMTs arrived, the 35-week-old stillborn child was not responsive. Ms. Fisher initially told paramedics she didn't know she was pregnant. And then in the hospital, allegedly, she admitted she knew she was pregnant and made statements about finding it difficult to handle a pregnancy again. The medical examiner in that case initially determined that the cause of death was asphyxia. But for our purposes, and sort of by all accounts, some of the strongest evidence in that case turned out to be searches on her phone about how to buy abortion medication online. And that data was allegedly obtained through a consent search of the device. Moving to 2022, a case that started this spring. In Nebraska, a mother and daughter are being charged with crimes related to the ending of the daughter's pregnancy. The mother is charged with performing an abortion without a license and performing an abortion past 20 weeks. The daughter is charged with mishandling human remains and related charges. Initially, it was determined that the death was consistent with a natural stillbirth. But then during interviews with law enforcement, the daughter consulted her Facebook Messenger to remind herself of the date and time the pregnancy ended. which coincided with a conversation she said she had with her mother via Facebook Messenger. So police use that to obtain a warrant from Facebook and recovered messages of the two of them discussing what appeared to be planning an abortion and concealing evidence. So I have up on the screen, this is actually public record of some of the messages that were obtained in that warrant. These are just a portion of them where they appear to be discussing abortion medication and how it works. Using that information obtained from Facebook, the government then went back and obtained a warrant for all of the electronic devices in their home. And as a result of this warrant, they in total recovered 13 devices. This included everything from laptops to tablets to smartphones. And I think we can all imagine how much personal data that is. These devices contain everything about their lives, things that they have even forgotten: communications, web searches, browser histories, location information. The amount of data is frankly terrifying, both in scope and in detail. So this is why courts have over the years sounded alarms about these types of electronic searches. And these are just a few quotes from decisions. One particularity is more of an aspiration than a rule. Electronic warrants are the closest things to general warrants in the history of the Republic. They risk rendering the Fourth Amendment irrelevant. While this language is alarming, it is not hyperbole. This is where we find ourselves at the current moment. Before we get back into pushing back on these searches and raising Fourth Amendment challenges, I think it's important to just discuss how device searches are actually done and how account searches are done, so we understand the mechanics. First, talk about device searches. And with device searches, the most important thing to know is just that there are multiple steps. It is not a single search and seizure. And the first step is the extraction process, and that's essentially just the copying of the data from the device. The second step is the sort of search or analysis of the data recovered in step one. And then the third is segregating responsive data from non-responsive data. And what's important to understand is that at each step, the government has ways in which they can limit the data that they're accessing and viewing. And for us, that means that there is a place at each step for us to raise a challenge to the warrant and the execution of the warrant. So digging into step one, I'm going to use Celebrite as an example because they are by far the market leader and the most common tool used. And frankly, across platforms, they function similarly. The important thing to know in step one is there are different types of extractions. At the sort of lowest level, least invasive, there is something called a logical image. And that's essentially if you were to pull out your phone and look through, scroll through every app and every piece of data, you would have access to all the same things. So it's a copy of the things you see on your phone. Then there's something sort of the next slightly more invasive is a file system. That includes all the things that you can access on your phone, as well as some deleted data and some metadata. Then the most invasive type of search is something called a physical extraction. That is the sort of binary files that you might get in Discovery. Those are the ones and the zeros. That's everything. Deleted data, metadata, every sort of bit and byte on the phone. So that is by far the most invasive. There are other extraction types, advanced file system, advanced logical. The important thing to know here is just that there are different types and each one of them recovers different types of data. The other important thing to know is that within some of these extractions, there is an ability to limit the data that is actually pulled off. Both with what's called a selective file system and certain types of logical images, they can actually select before, or I guess during the extraction process, what data is going to be copied and what is not. And I've got an example up on the screen here of a select file system in progress. You can see here that they can select Gmail, they can select Twitter, they can select all different types of data and limit what is actually pulled off, saved, and usable by the government using that process. So step 2, this is a search or analysis of that data that was obtained in step 1. So here again, we're using Celebrite as an example. The examiner takes all of that data that was extracted from the device and sorts through it for incriminating evidence. Or hopefully not just incriminating, what is named in the warrant. The key thing to understand here is that the police do not need to look at every file to find what they're looking for. Celebrite has a very simple interface that parses out data for them in advance. And I've got an example here of what you might see in a reader, but this is essentially the same interface that they're looking at in things like Physical Analyzer, which is what the sort of person conducting the extraction will do. And you can see calls are separated out in a nice drop menu. Same thing with messages and location information. So if they want to access just messages, they can do that by just selecting messages and looking through that. They can also, within each type of data that they're looking at, use keyword searches. They can also use keyword searches across the entire device. So say they were looking for a specific text message, they could actually enter that content in and search across the whole device or search within messages. You can also conduct keyword searches for usernames or for phone numbers. They're also, within a lot of these tools, they are rolling out AI functions. So AI that can identify guns, AI that can identify drugs, or they already have a very well-known AI that identifies potential child pornography. The thing to know is that there is no reason here to dig through images in order to find text messages. No reason to dig through emails in order to find a phone call. So step 3, once they have found what the warrant allows them to find, they should segregate that data and end the search. So they can use a nice feature within Celebrite and all of these other tools, which I have an example of from Celebrite right up here, that allows them to actually go through and just click on pieces of data that they have identified as relevant or within the scope of the warrant. Then they simply go to generate report. They can isolate that information, generate a report, and segregate that data from non-responsive data. It's incredibly easy and quick. Prosecutors will often say you can't do that. You can. It's easy enough that literally anybody can do it within a short time of using the tool. Talk about account searches. The nice thing to know about this is it's, the same 3 steps. The only difference is that step 1 is conducted by the internet service provider, not by the government. So essentially the internet service provider is given the warrant and they are tasked with segregating out the data before providing portions of it to the government. Know that segregation is absolutely possible there at step 1. And I think in some ways your arguments are stronger when it comes to online account searches. Step 2, these are also, in most cases, the government is using tools just like Celebrite or Celebrite that do an analysis of all of the data pulled off so that they don't have to look through every sort of line by line. What they might give you is just the PDFs. They are generally using a tool to help them dig through it faster. And step 3, again, if they're using that software, it's very easy to segregate responsive from non-responsive. So now the interesting part, how to challenge these searches. And then there are two big recurring issues we see with both device and account warrants. The first is that probable cause that a crime has been committed does not mean probable cause to search a device. I recognize that may seem obvious, but especially since if Riley has any meaning, that can't be the rule, that can't be enough. But courts are just starting to sort of come our way on this. So keep an eye out for that. Also, what we see a lot more often now, I think, is that warrants, these warrants that are based on generalized training and experience. These warrants go something like this, criminal has a phone. Based on my training and experience, criminals use phones in order to commit crimes. Therefore, the phone has evidence of a crime. We just need to get judges to understand that the probable cause must be specific to the case, not generalized training and experience. That can be considered as a factor and absolutely should. But it can't on its own establish probable cause. And there is, good developing case law on that. Despite having, I think, some bad case law in areas as well. And so some of that is in your materials. It's also worth quick review on particularity and breadth. You guys may understand that fairly well, but for some reason, judges and prosecutors seem to not be able to grasp it in the context of electronic warrants, or at least their decisions mix the analysis between the two. Particularity is the requirement that a warrant must clearly state what data is sought. Breadth, meanwhile, it just deals with the requirement that the scope of the warrant must be limited to the probable cause on which it's based. So what that means is that a warrant can violate the particularity clause either by seeking specific data for which there is no probable cause, or by giving so vague a description of the data that there's no meaningful restriction on what is seized. Probable cause and breadth are interrelated. Breadth is really just a sub issue of probable cause. So assuming the government has named what they are searching for, they must establish probable cause that the crime has been committed and that evidence of the crime exists on the place to be searched, the phone, the account. Breadth is really just the requirement that there must be probable cause for each item or piece of data that is named, right? So if they haven't established probable cause for something that is specifically named, the warrant is overbroad as to that piece of evidence. So jumping back to particularity, again, it's just the requirement that the warrant name the data to be sought. Although particularity and breadth are sort of distinct challenges and you should analyze them as such, if you have a warrant that is just a general warrant and completely lacking in particularity, it is by function, by necessity, it is also overbroad. So if the government says it has probable cause to search a device for text messages and the warrant says you may search this device for any evidence of an illegal abortion, that's both insufficiently particularized and overbroad. The other thing to understand is that particularity operates on a sliding scale based on the complexity of the evidence and the case and what is known to the government. So if on the one hand, the case is very complex and it is something like somebody operating a drug ring on the dark web, the search of their laptop will not have to be as particularized as on the other hand, you have a case where it is a search for a single or a few text messages between two known parties. The flip side of that is that when the case is less complex and the evidence is less complex, the government knows more, they have to be very, very particularized. So if they are aware of a single text message, they have probable cause to believe that a single text was exchanged between two parties. They have to name that exact text, right? They should be naming that text and that exact communication, nothing more. So I just thought it might make sense to sort of go over some of the challenges to a Facebook warrant based on some common issues in these cases. So we're throwing up a sort of likely scenario in one of these, a potential prosecution. So person A is suspected of, this is from the affidavit, person A is suspected of having illegally terminated their pregnancy. Person A arrives at a hospital after claiming to have had a miscarriage and provides conflicting answers about their pregnancy. A known and reliable informant informs police that person A stated they hated their partner and wanted to have an abortion. Person A also posts on a Facebook group saying, or asking, does anybody know where I can find misoprostol? Person B then comments to that post, I know somebody, DM me. The warrant then authorizes Facebook or commands Facebook to disclose to the government all information associated with a Facebook account, user ID related to person A. And then lists, including but not limited to, which I'm sure you've all seen in all of your warrants, a laundry list of materials consisting of basically every piece of data that Facebook keeps on users. Then in a separate provision within the warrant, the government is authorized to take all of that data that consists and search it for and seize information that consists of a violation of whatever local state law, including but not limited to posts on Facebook groups referencing abortion medication, and any direct messages discussing abortion or medication. So just to kind of dig into this a little bit, one thing that the warrant, I think, does correctly is that it treats step 1 and step 2 separately. So generally these steps should be separated because the government might be authorized to seize a slightly broader amount of materials in step 1 than they are in step 2. That being said, that is sort of where what they got right in this warrant ends. So the problem here is that step 1 allows a complete overseizure, right? It is of every piece of data that Facebook keeps on its users, regardless of whether or not there is probable cause to believe that is connected to any crime or evidence of any crime. So it is both, because there are no limits placed on it, it is insufficiently particularized and overbroad, right? Because that is left completely open to the government as to what they are allowed to get, and to Facebook. Step 2, the government it has its own problems. It is slightly more narrow, right? It does restrict it to posts on Facebook groups referencing abortion. It does direct them to also find messages discussing abortion. But as we discussed earlier, the government in this case, this is fairly straightforward. They know exactly what the Facebook post is, what group it is under, and therefore they should have to name it with specificity. They should name the actual post, the group. They should do more than just say groups generally, right? They have a single posting that they have probable cause for. Same thing with the direct messages. They should be restricted to conversations with person B. So this warrant is both insufficiently particularized and overbroad as to both of those, as to both step 1 and step 2. I want to also sort of take a look at what a device warrant example might look like. In this fact pattern, the affidavit states that person A is suspected of illegal terminating their pregnancy in state 1. Person A stated that they had been prescribed abortion medication from a doctor in state 2 after being referred there by Dr. B. Another known and reliable informant informs the police that Dr. B refers people to clinics in state 2 using their personal cell phone. Dr. B was arrested, and with their personal cell phone, the warrant then authorizes the search of the iPhone that was recovered for any evidence of violation of a crime and assisting with a violation of a crime in this under state law. And then the inevitable, this includes but is not limited to text messages, basically everything that could possibly exist on a phone and constitute evidence. Here, things do get a little more complicated because the government knows less. And this is potentially more complex because the government knows that they have been involved in, past instances and are you visiting this over some unknown period of time. That being said, the warrant appears to be completely overbroad and lacking in particularity because there is no real restriction other than saying, look for evidence of a crime. These are very common. We still see these across the country, just, find evidence of this crime. So even though this gets a little bit harder than the other warrant, this is still ripe for challenge, and I think we will continue to see these types of warrants. Before we move on to the next topic, I just want to plug some resources we have. If you go on our website, we have motions, orders, and hopefully more to come, and you can contact us to talk about any warrants you might get. So I'm going to hand this over to Mike and Jimena.
Great. Thank you, Sid. I'm sure you can tell by what you just saw that is sort of just the tip of the iceberg in terms of device searches. And, as we've contemplated this and the different types of criminal laws that are coming into effect, can hit anybody from some of the scenarios that Sid outlined, which is somebody looking online for medication, somebody communicating either in text messages or DMs with someone about, how to terminate a pregnancy. It could also affect, statutes that are looking at criminalizing doctors or even giving them affirmative defenses where they say, well, I had to do this to save the life of the person who's involved. And then they decide they're going to seize all the doctor's devices and look into them to see if there are messages that said, well, look, I was kind of on the fence, but I did what I had to do. And this is what I said, whatever they're looking for. You all have experience with this, right? If you've had any case that involves a digital device, they try to get every device and get everything on it. And so we do expect that this is something that will begin to play into these cases. Next, we're going to hear from Mike Price, who's the litigation director at the Fourth Amendment Center, who has a comprehensive knowledge of the history and the implementation of the Fourth Amendment. So from general warrants on, and has litigated probably more cases on reverse search warrants than anyone at this point. Basically looking at them as general warrants. And so as we think about what some of these statutes might do to track down people who are trying to get to places where they might get abortion care or reproductive health care, these kinds of reverse search warrants will come into play. And so I'm happy to turn it over to Mike, who can sort of walk you through that.
Thank you, Jimena, and thank you, Sid. Device and account searches usually happen after the police have identified who they're after. And as Sid explained, they could be used to establish intent in pregnancy-related cases. But how might police identify people to investigate in the first place? Without a tip, as in the Nebraska case, law enforcement might resort to something called a reverse warrant. We've seen them in other cases involving robberies and murders, where the police know a crime happened, but they don't have a suspect. They don't have probable cause to search anyone in particular. So they get a warrant to search everyone's data and come up with someone later. That is a reverse warrant, or what I like to say, what happens when Google searches for you. There are two types that I'm going to talk about today, geofence warrants and keyword warrants. And we're going to talk mostly about Google because Google has an immense amount of both location data and search data. And that's where police have been turning to with these warrants. In fact, Google now reports that more than a quarter of all the search warrants they get, more than a quarter of the 40,000 warrants they get are reverse warrants. And that's a fourfold increase since 2018. So if these are being used for robberies and murders, we should expect them to be used in pregnancy-related investigations as well. We're first going to talk about geofence warrants and then keyword warrants. And I'll provide some scenarios where you'll want to be on the lookout for them to show up. We'll start with geofence warrants. The idea here, again, is that police don't know who they're looking for. So they go to Google and they get data on all devices near the scene of a crime. Google searches a database it calls Sensor Vault, which contains something called location history. Location history is a specific kind of location data. And they search everybody who has that type of data, who has that service enabled in order to conduct one of these searches. It's about a third of all Google users. And you can check to see if you have it enabled by going to your Google Maps timeline and seeing if there's data there. But it's a lot of people. It is an epic dragnet requiring Google to search hundreds of millions of accounts to produce this information, and all without probable cause for any of it. Geofence warrants typically follow a three-step process. This is an example here of what they look like. Police will draw a geofence by identifying latitude and longitude coordinates. It can be a circle, it can be a square, it can be a trapezoid, any closed shape. The warrant will also generally identify a window of time and tell Google to provide the data for any device that is inside the geofence during that time. Google has to search all accounts here. It says that it provides anonymized data for devices that are inside this geofence. I'm putting anonymized and inside in sort of air quotes here, because in practice, that data is not really anonymous. And there is really an open question about how to count which devices are actually inside. Both of those issues are a little bit beyond the scope of today's presentation, but the Fourth Amendment Center has plenty of resources on those issues available on our website, and we'll provide a link at the end. This is what location history data looks like. One of the things I just want to flag here is this maps display radius over on the right-hand side. Again, it's a little complicated, and we're not going to get into it today, but location history is not like other types of location data. It is Google's estimate of where you are based on, frankly, other people's data. And they have a margin of error, that blue circle that you see on your map, for each bit of location data. Sometimes it can be fairly accurate within a matter of meters. Sometimes it can be wildly inaccurate. And we've all sort of had that experience of being in one place and your GPS saying, no, you're in the lake. So, it can really vary between being pretty accurate and being pretty inaccurate, depending on the source of the data and how that algorithm is working. The second step is what happens when law enforcement will identify what they call devices of interest. So they'll look at that anonymized data. They'll say that one seems like I want to know more, and they'll get location history data, not just for the crime scene, but for time both before and after the time of the incident. And they'll be able to actually follow and see where people started from and went to. And step 3, they go back to Google and they say, okay, now we have our finalists, so to speak. And Google will reveal their names and their subscriber information. So the steps here may vary. We have seen warrants with just 1 or 2 steps. 3 steps is the most typical, but that's the way that one of these warrants generally works. I want to, pause here because it might interest you. Why does Google even collect this data? And the answer is to sell ads. They advertise based off of this data, even though they don't give it out directly to advertisers. And for them, that it's fine to be a little inaccurate. They don't need to know precisely where you are to sell you an ad. They just need to know generally where you are. They're doing this to sell ads, not solve crime. So if they know that I like tacos and they want to sell me ads for tacos on Tuesday, then they just need to know when I'm near the taco truck. They don't need to know exactly where I am in relation to it. But what if someone didn't want to sell me ads for tacos, but instead wanted to target people with ads during their visit to a clinic? That is exactly what happened starting in 2016, when someone decided to use Google's advertising feature to geofence abortion clinics and to send pro-life ads to everybody in the area. Coincidentally, this is 2016, the same year we started to see police using geofence warrants. So for as long as we've had geofence warrants, we've actually had people using them to harass people seeking healthcare. In the years since, many of the states that now criminalize abortion have become very accustomed to using geofence warrants. Texas, Florida, Alabama, Ohio, Arkansas, and South Carolina are some of the most frequent users of geofence warrants. And they are using them to investigate things like burglaries and robberies. And we can, I think, be sure that they will use them to enforce new pregnancy-related laws as well. This could mean a geofence around a clinic to identify not just who went for a visit, but also who took them there, who was working there at the time, who was the doctor, who was the staff. It could mean a geofence around a place that ships or stores misoprostol, or a place that prescribes or dispenses it. I think geofence warrants are unfortunately going to be a part of these sorts of investigations in the future. And in order to challenge them, there are three things that we generally have to argue. First, that a search occurred, right? That there's an expectation of privacy or property interest in this data, that the warrant itself was invalid for many of the same reasons that we were talking about before, but overbreadth and lack of particularity. And then finally, no good faith. We're not going to get into the good faith analysis here today, but focus on the first two parts, specifically the expectation of privacy issue here. It may seem odd because we're talking about geofence warrants, but the government will say they didn't need one because of something called the third-party doctrine, which says that there's no expectation of privacy in information that is voluntarily conveyed to any third party. It's a relic of another technological era, but we still need to argue it doesn't apply here. And one of the ways to do that is by pointing to a case called Carpenter v. United States. And Carpenter was a 2018 case where the Supreme Court held that a warrant is required for 7 days or more of historical cell site location information. And it found that the third-party doctrine didn't apply for three basic reasons. That the data provides this depth and breadth and comprehensive reach, that it provides basically a window into the privacies of life, revealing familial, political, professional, religious, sexual associations, and that using cell phones really isn't like voluntary anymore, that they're an essential part of life. And that means sharing information with service providers. So we're going to take that case and apply it to location history, and say, look, it's similarly comprehensive, right? You actually need less of it than cell site data to figure out where someone was. With cell site data, you might see a pie wedge that looks like this and be able to figure out that somebody was in the neighborhood. With location history data, you can put somebody on the block, in the building, or in some cases even on the floor, depending on the inputs that are available to Google. So location history here can reveal those same privacies of life. And in fact, this is a scenario that the Supreme Court contemplated when holding that you need a warrant to GPS track somebody. It was Justice Sotomayor who was pointing out how this sort of data can reveal the most intimate aspects of our lives. She says, including trips to the psychiatrist, the plastic surgeon, the abortion clinic, the AIDS center, the criminal defense attorney, and on and on. So the argument here is that location history data is just as sensitive. And assuming that there is an expectation of privacy, why is this warrant invalid? We're saying it's a general warrant, right? And it's not just a little bit overbroad. They're searching hundreds of millions of people, everybody with location history enabled, a third of all Google users. And as Google tells us now, at least as of 2018, that meant 592 million people are getting searched every time Google has to execute one of these search warrants. This is an epic dragnet. Hundreds of millions of people without probable cause to search a single one. It really doesn't get much more overbroad than that. And so we say that it's a general warrant. We also attack these for lack of particularity. They are profoundly lacking at every step. The idea behind the particularity requirement is that warrants need to be very clear about what police can search and what they can see, so that they don't have any discretion. But geofence warrants are anything but particular, starting with step one, because they can be very inaccurate sometimes. It becomes difficult to decide who's actually inside the geofence and who's not, producing a lot of false positives and false negatives. And then in step two and step three, it's even worse. It explicitly gives law enforcement the authority to decide whose data is going to be further searched and seized, who they're going to select as a device of interest and get that contextual data on, track them around and see where they went to and where they came from, who's going to make it to the finals and have their account information explicitly revealed by Google. There's really no way around it. These sorts of warrants give police the power to decide whose data to search and seize. That is the hallmark of an unparticularized warrant, and as we argue, unconstitutional. It is not just us arguing it anymore. We actually have some cases here now addressing the constitutionality of geofence warrants and agreeing that they are in fact unconstitutional. This is a case that we litigated this year, and the court in Virginia held that the geofence warrant, it was around a bank robbery at the time, was unconstitutional because it lacked particularized probable cause as to every Google user in the geofence. So the court is saying that, you know what, you're going to need to have probable cause for every single person that shows up in step one. And that is a pretty high bar as a practical matter, because if the police knew everybody that was in the area at the time, they probably wouldn't need a geofence warrant. The whole idea here is that they don't have cause for everybody that they're searching. and therefore that it is unconstitutional. The court also held, with respect to particularity, that steps 2 and steps 3 gave the police improper discretion, that it provided them with unbridled discretion to decide who to search further, and again, for that reason, was unconstitutional. The briefs and transcripts for this case are available at our website, nacdl.org/Chatri. And now I'm going to turn briefly to the other type of reverse warrant called a keyword warrant, which is like a geofence warrant, but for Google searches. It's what happens when the police don't have any suspects and they say, hey, Google, tell me everybody who searched for X, Y, or Z over a period of time. It could be an address, like it could be a name, or more general terms or a group. If you see one of these, it will likely be a warrant directed to Google with a list of search terms. This is here from a case in Colorado, which is the first constitutional challenge to a keyword warrant. But these have been around for many years as well, even though they're really just getting around to litigating them now. When executing a keyword warrant, Google has testified that it requires searching data belonging to authenticated, i.e. signed in users, and also people who are unauthenticated, i.e. not signed in. So everybody who runs a Google search, whether you're signed in or not, is going to be subject to this. It's slightly different from location history in that there's no opt-in. If you are authenticated, then Google attaches something called a Gaia ID to you, Google Accounts and ID Administration. If you're not signed in, then Google attaches something called a browser cookie ID, which is a unique number that Google assigns to your computer browser. And you can't delete that. And it is not clear how long Google keeps it for. But what happens is law enforcement will go to Google with this warrant. They'll say, tell me everybody who searched for something over a period of time. And Google will produce something that looks like this. This is what a keyword warrant return looks like. It is in the form of a CSV file, which is basically like an Excel file. And there are a few things to note here. First, here is the Gaia ID or the cookie ID. So whether you're logged in or not, here's the ID that Google is assigning. Google also will produce the IP addresses associated with the search. So even though this is supposedly an anonymized, truncated ID here, this is a full IP address over here. And that's going to allow law enforcement to go to a service provider with just a subpoena and figure out who owned that IP address at the time. You'll notice that it doesn't have any geographic limit whatsoever. Even though, say, the case occurred in Colorado or Arizona, doing a keyword search means searching everyone who ran a Google search all over the world. There's no way to limit it at the front end by geography. And you'll also see that even if the warrant here was just for 123 Main Street, the results that Google gives back will include other search terms in addition to, say, 123 Main Street, whether that is additional location information or the name of the place, but it won't be exact. So it's not, it doesn't take a ton of imagination to see how police might use a keyword warrant to investigate pregnancy-related crimes. People are going to the internet now for health information as a first step before sometimes even consulting a doctor. So, the rise and the trend now is to seek medication online, mifepristone, abortion pills, misoprostol. You can see how even searches for what would otherwise be considered, medical care could turn into either an attempt to establish intent or an attempt to identify people to prosecute. So challenging keyword warrants is a lot like challenging geofence warrants. It's still important to show that there was a search to demonstrate either an expectation of privacy or property interest. It's still important to show that it is unconstitutionally broad and lacking in particularity. I think the general warrant argument is even stronger here. There are obviously other constitutional concerns that heighten the probable cause and particularity requirements. And then, of course, to argue against good faith and for suppression, which we cover in other trainings. To establish a Fourth Amendment interest, despite, again, this data being held by third-party Google, you're going to argue that search history is some of the most private data imaginable. Search engines like Google are really that gateway to information online, and sometimes the first and only way people can find health information that they need. Unfortunately, every single query can, reveal deeply private facts about people, things they might not share with their friends or their family. And every day people type really deeply private stuff into that search box, stitch those together over time, and they really do form a tapestry of daily life. And I think, it is also important to point out that even Google believes that this information belongs to the user. It's your property. Even though Google is recording it, it's recording it as a part of your account contents that you could download or delete if you wanted to. So the idea is that you not only have a privacy interest in it, but you have a property interest in it as well. In terms of substantive challenges, like a geofence warrant, we're going to argue that it is overbroad. And that is to say, there is no probable cause here to search. And we're talking about billions of users, right? Google has said they're getting billions of searches every single day. Law enforcement is not going to have probable cause to search billions of people. And it is not enough to cite generalities about cell phones or about Google usage. There is not going to be probable cause to seize the data of everybody who searched for the terms in question. It assumes that every responsive search would be evidence of guilt, and that is clearly not the case. When it comes to particularity, it is critical to note that the place to be searched in the warrant is often just labeled Google headquarters, right? 1600 Amphitheater Parkway, and not any particular user accounts. The government may argue that it's just a database or that it is just computers searching zeros and ones, but this is not just any database here. The database is the digital equivalent of a billion-story apartment building, housing the modern-day papers and effects of every person who has used Google Search or Google Maps. Providing the street address for Google headquarters here is pretty meaningless and misleading, like serving the warrant on the building manager here to have them peek inside everybody's unit and inside everyone's diary. All right, so that's probable cause, that's particularity. We have resources on challenging both geofence warrants and keyword search warrants on our website here under our reverse warrant resource page. And again, if you get one of these, please reach out to us. We have additional trainings and can help with direct litigation assistance as well. I will turn it over now back to Jimena and Claire.
All right. Thank you, Mike. I think, he proved me right. I don't know anybody who knows more about the Fourth Amendment, the history of the Fourth Amendment, and what looks like a general warrant. And I guess along those lines, I have the opportunity to introduce Claire Garvey, who is Training and Resource Counsel for the Fourth Amendment Center. Claire came to us from the Center on Privacy and Technology at Georgetown Law, where she accumulated more information about the way face recognition works than probably anybody. And I say that in the sense that she dug into, FOIA requests, looking how departments use them, looked into the companies, looked into the warrants. And so it is again, sort of a place where, just like Mike's laid out how these types of reverse searches could certainly come into play when law enforcement is trying to figure out who was looking for certain types of medication, who was going to certain areas of town where there may be some kind of abortion care provider, who was crossing state lines. This is just yet another way that people may be identified and tied to places and to practices that states are currently criminalizing. And so with that, I'm happy to turn it over to Claire.
Thanks, Jimena. Happy to be here with all of you today. As Jimena mentioned, I will be talking about face recognition. All right, I'm going to separate this presentation into two parts. The first is to look at how face recognition is typically used in police investigations, because this is likely how it's going to show up in one of your cases, regardless of whether it's focusing on healthcare or someone seeking an abortion or a different type of investigation. And then I'm going to look a little bit at face recognition as a surveillance tool, because I think this is one of the unique cases in which, or ways in which, face recognition could impact those seeking abortion care moving forward. And it could be also ways that prosecutors and law enforcement officers are thinking about how to maybe start enforcing highly restrictive bans on abortion. By way of introduction, face recognition is incredibly common. If you haven't had a face recognition case, that's not because it's not being used in your jurisdiction. It's more likely that it just hasn't been disclosed, but it may very well be used. Just a brief overview of how prevalent it is. We estimate conservatively that over half of all American adults are in a face recognition database that is routinely accessed by law enforcement because they got a driver's license. Most driver's license divisions run face recognition, and at least 33 states enable law enforcement to access those in order to conduct criminal investigations. Over a quarter of all law enforcement offices have access to a face recognition. This is who we could confirm back in 2016, back in my old job with the Center on Privacy and Technology. We could confirm that a quarter of all law enforcement offices were actually accessing or could access systems. In reality, the number is much higher. And we know that it's been used in hundreds of thousands of cases, going back to at least 2001, when the first systems were set up in Michigan and Florida. To make matters worse, I'll be referencing a company called Clearview AI. If you haven't heard of them, basically Clearview AI has scraped 30 billion images and counting off the web. Their goal is to hit 100 billion images. To put that in context, that's about an average of 14 images per person on this planet. So as a practical matter, when we talk about half of all American adults, that is a gross understatement of the simple fact that thanks to this private company, face recognition, as a practical matter, pretty much touches anyone whose photo has appeared on the internet. And more about this company in a few moments. How does law enforcement use face recognition? This is going to be a very quick overview, as Jimena mentioned at the beginning of this talk. This is a bit of a sampler. We have resources and other trainings on NACDL's website that go more in depth. And I'll be doing more trainings on face recognition as well. But some of the terms and introduction to how it works generally. What's at issue is there's a photo of let's say, a person of interest in a crime that law enforcement is seeking to identify. This is called the probe image. It is an unknown individual. In order to try to identify it, law enforcement will upload it and compare it to a database of known individuals. Historically, these have been mugshots, increasingly it's driver's license, visa, passport images, and yes, now the internet, essentially. The face recognition program searches in a matter of seconds, upwards of 1 billion photos, if those are on offer, maybe 30 billion if it's Clearview AI, narrows the possible matches, I'm putting that in scare quotes, down to what's called a candidate list, a list of possible matches that an individual then goes through and determines whether the face recognition system made a possible match and who that individual might be. And this generates an investigative lead. Now, I'm going to spend a lot of time focusing on what an investigative lead means and what law enforcement traditionally considers face recognition to develop, but what we've actually seen happen in practice. So this is from Michigan State Police, but it's pretty typical for law enforcement across the country, where they do not consider a face recognition match to be a positive identification. Instead, they say, no, it's an investigative lead only. It's not probable cause to make an arrest. Further investigative steps are needed before that probable cause threshold is met. Well, what does this actually mean? As a practical matter, this is probably why a majority of jurisdictions have not seen face recognition show up in cases. It might be why you haven't heard about face recognition in any of your cases. It has less to do with performing a valuable check against misidentification and more about hiding face recognition from judicial adjudication or from the defense. Why do I say that? I say that for two reasons. One is we have seen a very concerning pattern emerge that even in jurisdictions where officers are expressly told face recognition is not probable cause to make an arrest, officers are not given additional guidance on what constitutes sufficient additional investigation, and as a consequence, rely almost entirely on face recognition to make an arrest, often with severe negative consequences. For example, Robert Williams was arrested by Detroit police in 2020. This was an investigation of a robbery at a Shinola store a year prior, where there was video of the video of the crime, which was uploaded to a face recognition system, which generated possible matches. The only additional investigation that the officers took was they went back down to the store, showed the video of the crime to the security guard who happened to be on duty that day, who was not a witness to the crime. She was not on duty at the time of the robbery, and asked her to perform an eyewitness identification off of a 6-card photo array. Robert Williams was wrongfully arrested. She made a misidentification, and he spent, I believe, 72 hours in prison and a very, very long time combating this misidentification and wrongful arrest. In a, unfortunately, pretty typical case, from the limited information that we have, Najir Parks was wrongfully arrested in New Jersey. Officers were investigating essentially a hit and run where a fraudulent Tennessee driver's license was left at the scene. That driver's license was run through face recognition, misidentified Najir Parks as a possible suspect. The officer conducting the investigation was not a witness to the crime, just did a visual comparison between Najir Parks's photo and the Tennessee driver's license and decided they were the same people. Now, this case was bad enough. It could have been a lot worse. Najir Parks seriously considered taking a plea deal to 20 years in prison because he was really, really afraid that he was going to get a more severe sentence if he went to prison. He was really afraid of the trial penalty. Fortunately, he did not, and he was eventually exonerated. He spent 6 months with a felony on his record, though. And I have maybe 10 other cases where the fact pattern is remarkably similar. So this question of what it means for it to not be probable cause is incredibly unclear, and it does not mean it's not being used as positive identification before an arrest is made. Even short of that, even if additional investigative steps are taken, there's still a fundamental question that needs to be asked and has not been answered when it comes to face recognition. And that is, how reliable of a lead is it? Is this a reliable way to identify somebody, or at least to generate an investigative lead? You will often hear from law enforcement, from the media, and possibly even from judges that face recognition is an algorithm. It's somehow mathematically magic. There's this aura of mathematical certainty that comes around the fact that it's artificial intelligence. I'm here to tell you that face recognition is none of those things. There is an artificial intelligence component to it. This is a forensic investigative method that can be classified as a subjective feature comparison method, along with everything from fingerprinting, DNA, to hair microscopy, bite mark analysis. Name a investigative method where you take an image of one thing, compare it against images of another thing, or the same thing, and try to see whether they match. The question is, where along the vast, vast spectrum of reliability when it comes to comparing two things and determining whether they match, does face recognition fall? And the answer is we actually don't know. I would argue that face recognition, and I go far more in depth in other trainings on this, is that if we actually break down face recognition into its individual steps, it is incredibly unreliable. There are numerous areas where unreliability, mistake, error, etc., can come in such that face recognition is fundamentally not a very reliable identification procedure, should not be relied upon, certainly for probable cause, but is also highly challengeable as a way to connect an individual to a crime or confirm that they are the subject of a photograph. This includes the algorithms are new. They might be pretty good. They might be pretty terrible. The algorithms suffer from racial bias. They perform better on certain skin tones, race, sexes, and ages than on other people. There is no such thing as widely accepted training protocols or certification for the experts who are running these face recognition systems. I put experts in scare quotes again because there's no certification for this. We actually see in most jurisdictions, the officer investigating the crime can run their own searches, and they might have anywhere from 2 hours to 40 hours of training on performing this function. The photos might be of poor quality, meaning that the algorithm actually doesn't have much to go on to make that feature comparison. And name a contextual or other cognitive bias, and chances are good it A, shows up in the face recognition system, and B, is not in any way acknowledged or addressed. A few examples of this. If we were all in the room together, I would call on somebody and ask, which of these do you think cannot be submitted to a face recognition program? It's a trick question. They all can, because there's no such thing as minimum photo quality standards prior to a photo or non-photo being submitted to a face recognition search process. All of these suffer from pretty severe issues and that are going to affect the accuracy of a face recognition search. The one on the left is not clear enough to generate any sort of identification. The one in the middle is a forensic sketch, meaning that it is an artist's rendering of what they hear a witness able to recall about a subject of an investigation. Lots of room for error. And the one on the right, obviously, is something that camera systems are going to come across frequently right now. A majority of the biometric of the feature that is being compared is actually obscured. Another example of where error creeps in is photo editing prior to submission to a face recognition search is relatively common. This was described in a Forensic Magazine back in 2017 by one of the detectives that set up the New York Police Department system as, excuse me, a very successful breakthrough in face recognition was Photoshop. For example, the technique of graphically replacing closed eyes with a set of open eyes to yield more results, to get the algorithm not to focus on other photos in the database where the subject's eyes are closed. He goes on to add that the color of the eyes doesn't need to match. If you're thinking about this as a forensic investigative method, as a subjective feature comparison method, you might be thinking, well, hang on, this is the intentional contamination of your evidentiary sample before you're actually running the comparison. That's correct. And that is, in the absence of it being not allowed, happens all the time. In one case in Maryland, where discovery was actually obtained by the defense, the officer acknowledged that there's no specific training or certification for anyone running these searches, that everybody in the state of Maryland can actually run a face recognition search. By everybody, I mean the officers. And that he was informally trained. There was no formal training that he could point to justify his ability to make that one-on-one comparison and say, yes, these two people are the same. And the illustration on the right is actually from a study that was done with Australian passport officers that showed one is looking at unfamiliar faces that have been narrowed down by an algorithm to the most similar is a very, very hard task. To look at that top photo and guess which one of those bottom 8 are a match is actually not a very easy task for a human, despite the fact that we like to think ourselves good at identifying people by their faces. So what do we do with all this information? Well, the Chicago Police Department, Bureau of Detectives, actually gave us a hint to this in a very concerning slide that they give to detectives on training for face recognition programs. And that is they instruct officers to not let software become exculpatory evidence. This is one, in recognition that the software is exculpatory evidence, and 2, an indication that this may be intentionally not disclosed and to make our jobs more difficult, but it does lead us to the answer here, and this is Brady disclosure. This is to argue that this is discoverable and to argue unduly suggestive identification procedure, or in the absence of disclosure, that the identification should be suppressed. I think there are at least 2 arguments to make here. One is negation of guilt under Brady, that the search is fundamentally unreliable because it lacks foundational validity, because there's plenty of room for bias and error, that there were other potential suspects. These algorithms are designed to return multiple possible matches, not just the individual that lands up getting arrested. Impeaching a witness. The system acts as an impeachable witness. The system operator, even though they may never be trained, is essentially acting as an expert witness in this case. We have a growing list of resources on the website, including a what to ask for in discovery, an example of a motion to suppress, which also includes a request for a Fry or Daubert hearing, some affidavit examples of amicus briefs, and some other reference materials. So in the last few minutes, I also want to pivot to looking at the unique ability of face recognition to multiply the I don't want to say effectiveness because that makes it sound good, but the effectiveness of surveillance. Face recognition can be put on the back end of live security cameras to conduct real-time biometric surveillance to identify people walking by a camera. It essentially facilitates turning any face photograph into a possible identification. I think the consequences in a post-Dobbs world is very well summarized by a clinic escort who points out that it's not uncommon for protesters to record individuals going into a clinic, and that, you can do as much as you want to try to avoid this. But if discovering names and where people live is as easy as taking that photo, then the precautions fundamentally don't matter anymore. And that is this concerning power that face recognition has. I think it's an accessible concept to think about, okay, where are these face photographs showing up? How might that now be a biometric identity, whether or not it's a reliable one? But I do want to highlight 4 types of surveillance systems, basically, to be on the lookout for. One is our standard CCTV camera systems owned and operated by police. Cleveland, Ohio has this, it's under preliminary injunction now, but they have a Heartbeat Act that, if it goes into effect, would enable felony prosecution of abortion providers starting at 6 weeks. Cleveland, Ohio, it's 15,000 cameras. They've spent $7 million on these 1,500 cameras. They have allotted an additional $4.5 million of COVID relief funds to increase the density of those cameras. And anytime anyone asks about face recognition or where these cameras are going to be, or any protections for individuals walking about their daily lives or participating in very, very sensitive behaviors like seeking an abortion, the conversations get shut down, yet individuals get told to take that conversation offline. So there's no transparency around whether or not face recognition would be used on this massive and growing camera system. One step removed from that are cameras owned by individuals, but fundamentally operated and acted upon by police. Public-private partnerships are relatively common. We hear a lot around Ring doorbells, but this is actually far broader than that. Here in DC, we have a public-private partnership. Detroit, Michigan has a really interesting one, and one that's worth flagging. It's called Project Greenlight. It's more than 500 cameras owned and operated by private businesses who enroll in a system where the cameras actually stream back to the real-time crime center. When this system was first put online, if you will, it included live face recognition technology, and some of the private entities that had these cameras included abortion clinics, standalone pharmacies. Michigan, again, is one of these states that has even though it's under preliminary injunction now, it did have a trigger law that might come into effect if that injunction is lifted. The third one to focus on, and this one very much flies under the radar, is camera systems owned and operated by private individuals, that the police actually aren't involved until an individual or coalition of individuals decides to raise it as an issue. San Francisco, not a place where abortion is hotly contested, or abortion access, but an interesting example where between 2012 and today, a private individual has spent over $4 million on cameras that cover a 135 block radius. And the footage is monitored and the system's operated by a private neighborhood coalition. Now, San Francisco has banned police use of face recognition. It has not banned neighborhood coalition use of face recognition. So private security systems are a potential workaround around otherwise pretty substantial protections against remote biometric surveillance. And then the fourth is it's not a traditional surveillance system, but I think we all can understand its surveillance capability, and that's the internet. Clearview AI is just one such company that has made photographs on the internet into biometric identification tools. There are other companies out there. PimEyes is one that anybody can upload a photo to. It's been used to dox people in the adult film industry. It's not a stretch to think about how it will be used by individuals or by law enforcement to seek the offline identity of folks that show up online seeking abortion care. I was thinking through how this might show up and just looking at the activities we're seeing now. Someone following an abortion care provider in Texas that happens to tie back to a photo, an actual photo of them. Someone joining a live stream about healthcare options. And since it's from their personal computer, their photo shows up for a few brief seconds at the beginning. Or someone's just out and about, happens to pass an abortion clinic or is actively seeking an abortion. Their photo is uploaded to a site dedicated to doxing individuals who are seeking an abortion or providing the care. So this is all hypothetical right now, but it doesn't take too much of a stretch, unfortunately, to imagine where face recognition will dovetail with investigation post-Dobbs.
All right, thank you, Claire. And so I'm sure shortly we're going to be showing your CLE code. I will say, after listening to that, maybe you have a headache, you need a drink. Any of those things can be true. I will say one of the things we know is that although these were sort of three distinct areas that Claire, Mike, and Sid were covering, in reality, they often intersect with each other and are used in the same kind of investigation. But here we are with our verification code. So it is the number 8, the letter H like Holly, the number 8, the number 4, the number 4, the number 5. So 8H8445. It will be posted again. It just, in a little bit, we are going to turn it to questions. But like I said, as you think about these things, just understand many of the tools that are being used or the tactics that are being used, whether it's a geofence, it's face recognition. You could see a scenario where they don't know who they're looking for. They do a geofence warrant, then they pull all the surveillance camera footage from the area, take photos from that. Once they land on a suspect, they seize every device the person owns, starts to dig into it. And so none of these things happen in isolation, right? And so I want to thank Mike, Claire, and Sid for laying that out. And I'm going to turn to questions. I believe the answer, I'm just going to do the easy question first. I believe the answer is yes, we are going to have access to slides. I guess if somebody thinks otherwise, you guys should let me know, but I believe the slides will be available. So I'm going to let that one go. But I think I just answered the wrong question. As far as the other questions that are in the chat, I know we're circling back, but I want to go back to device searches. And one of the questions that came up is there anything a lawyer can do immediately to enjoin the search of a device upon arrest? So something to do to stop it before they get all the information out, and don't limit it, and don't.
So as to, I think there was a two-part, it looks by the same person. There are ways to, if it was an account search and it was via subpoena, you could obviously move to quash the subpoena. I've seen that happen. That's generally not what.
Sid?
Yeah.
I hadn't read that question yet. So do you want to let people know what that question was before
digging
into that one? I was going to
two-part. Yeah. So as to a device, in that case, there's nothing you can do sort of proactively before the warrant is executed, but you can do a Rule 41G motion. So that would allow you, it's essentially a motion to return or destroy the results of an over-seizure, so an illegal search. In this case, often over-seizure. So that would be the mechanism for that. Sorry.
No worries. I muted myself. I just want to make sure that we're, everybody's getting all the questions that I'm having to go back and forth and read. So the question on, what happens when someone gets the email from Facebook saying that the government sent a lawful order requiring disclosure of the account information, and that they can tell you about it. What does Facebook have to tell the person about the subpoena? Was it a warrant? Do they have to produce an affidavit? Basically what happens or what can happen before any charges are filed.
The answer, if it was a warrant, the sort of answer is the same. Your mechanism is a 41G motion. And the warrant is done ex parte. Generally, you're not going to actually get a notification of those things because it will be under a protective order. So you're not going to know sort of in time. It will have already been executed. Sometimes I have seen with subpoenas that people have been given an opportunity to move to quash. So there is a way to do that before the execution is complete.
All right. And so now I'm looking at you, Mike, as somebody who's wondering if you use a VPN, does that somehow frustrate or prevent Google from finding your information?
A VPN will not shield your location data from Google. So the only thing a VPN is doing is confusing your service provider about where you're going on the internet, or confusing the websites that you're visiting about where you're coming from. The way that Google's location history works is that it's using the sensors that are on your phone to generate your location data and associate that with your account. If you use a VPN, it's not going to help you. With respect to a keyword search, it might, frankly, help you because if Google is of course logging all of your searches, whether you're logged in or not. If you're not logged in, then it's identifying you based on the specifics of your computer and your browser, but also your IP address, and that's how law enforcement will go back and sort of look it up. So if you were using a VPN and you connected to Google to run a search, it wouldn't change the device ID that Google gives you, but it would probably assign your IP address as your VPN IP address instead of your actual IP address.
Thank you, Mike. And so I guess this can be anybody. It's a question about what can be done with local legislation to provide protections in advance. I might actually start that one and then see if anybody wants to jump in. There's a number of either states or towns, cities that have taken some measures on some of these issues. So for example, in New York, there is pending legislation that would stop or end the practice of reverse search warrants. It has not yet moved, but there's legislation drafted. You won't be surprised to hear that Mike actually brief lawmakers to help them understand even how these warrants worked, because I think that's always the first hurdle, right, is the education piece and getting council members or state assembly members or whoever it is to understand exactly how these things work. Several places, and I'm sure Claire can weigh in if you want specifics, whether it's towns or even some states, have had bans or moratoriums on face recognition technology, limitations on them. Some places have just had laws that would force law enforcement to disclose what kind of technology they're seeking, what they're purchasing, and have that go through a different kind of analysis, including a racial justice analysis. There's a number of different ways that goes forward. I think if you have questions about specific places, you can email us. The email was at the n4ac@necdl.org. There's a number of different types of initiatives that would actually look to do some of these things legislatively. I want to get to a few more questions. There's a question that ended up in the chat, but they're a question essentially about when defense attorneys would be able to access technology. I'm assuming by the question that we're talking about face recognition technology to locate alternate suspects or provide clients with alibis. You're in luck. We've actually been looking into this issue, and Claire is in the process of providing a practice advisory on exactly this topic. So I'm going to turn it to Claire to talk a little bit about that.
Great. Yes. Just so happens that the company Clearview AI, I don't know if my feelings about them were sort of apparent enough. They are now offering a tool called Justice Clearview. The idea being that public defenders would be able to utilize Clearview AI's tool, upload an image. Clearview AI would search their 30 billion and counting number of images to generate a possible match. For all the reasons and very many more that I have outlined, that face recognition is not necessarily a reliable way to identify somebody. NACDL advises against using Justice Clearview and Clearview AI. Just two more reasons. One is they're the subject of multiple lawsuits right now. They have been deemed to be in violation of Illinois' biometric information privacy law. They are highly likely in violation of Texas's biometric information law. They also did create their database in violation of the terms of service of Facebook, YouTube, Twitter, a whole host of the websites that they did scrape. So the tool is in violation of laws and terms of service. So definitely question whether it's wise to move forward with a tool that may not work and has some sort of severe privacy ethical questions surrounding it.
Thanks, Claire. And I would add, I think, one of the difficulties is sort of the distinction between, is this tool sufficient to, say, find a witness versus sufficient to identify someone as a suspect and prosecute them? I think we're also concerned that by legitimizing the tools on one end, it's very difficult to turn around and go back to the same judge and say this tool is absolutely spot on in identifying someone else as the suspect, not my client. However, now that you've identified my new client with this same tool, it is completely unreliable and you can't use it. And so I think that there's a lot of insufficiencies and my own sneaking suspicion that Clearview is just looking for a new market for its product. We do have another question. I am going to then, if we have no more questions after this one, turn it to my colleague Vanessa to tell you a little bit more about some of the upcoming programming. I do want to make a note here, though, as we look at these questions, as we think about these issues, that in many ways, it is not surprising already. It is, it's been pointed out by many people that the type of criminalization that is happening, the types of statutes that are either enjoined or pending or even now in force, will weigh most heavily on marginalized and multi-marginalized people. So BIPOC communities, low-income communities, the people who are very much more likely to be in places that are heavily surveilled, they're more likely to have Android devices, which is tied to Google. The people who are much more likely to be at the crosshairs of all these intersecting types of surveillance. And so we understand this not just, as an issue about pregnancy-related crimes, abortion care, reproductive health care. This is very much a racial justice issue in terms of how these prosecutions are going to play out. And so, but going off of that, and who gets to use more privacy protected devices and who is stuck with Google, there is questions about what if you use more privacy protective browsers, you use Firefox or Safari or even DuckDuckGo. Does that help you sort of avoid the Google reverse search issue?
Yes, use DuckDuckGo.
It's not on their payroll, by the way.
It's my understanding that they don't keep logs. The government is going to Google because it is the largest honeypot out there. They have everyone's data already, so it's a very enticing target. They're not the only targets of geofence and keyword warrants. We've seen geofence warrants go to Uber and Snapchat, but it's very rare. I think in general, minimizing the amount of information you give any one company is a really good idea. And DuckDuckGo is a very privacy protective alternative browser.
Thanks, Mike. And seeing no more questions, I do want to thank you all for giving us the opportunity to talk about some of the issues that the center focuses on. We'll be working closely with Vanessa and the task force as this goes forward. Again, the CLE code is up on the screen, so 8H8445. And I'd like to turn it back to Vanessa, who is going to wrap us up.
Well, I would like to say thank you so much to NACDL's Fourth Amendment Center. You all did an incredible job of terrifying us a little bit about the possibilities of digital evidence in these cases and other cases. And I want to let everybody know that, of course, some of this just touches on the surface of many of these issues. So you can look forward to both more assistance for the Fourth Amendment Center when you ask them and you visit the website, and future webinars on a lot of these topics, taking a deeper dive, because there is so much more to go into. So thank you so much for that. I want to thank you all for watching. And also we would like to again acknowledge the Evelyn D. Reamer Fund, and to thank everyone who has donated through the NACDL Foundation for Criminal Justice in support of this work to make work like this possible, free webinars and CLE credits and all of that. Speaking of which, we were continuing this series about defending pregnancy-related prosecutions and defending cases related to the criminalization of reproductive health care, with the next scheduled webinar on December 2nd, Conspiracy, RICO, and Accomplice Liability in a Post-Dobbs World. You have seen the links in the chat. You can register for that. You have the link to the landing page for this project, so you can get updates about all the coming attractions, one of which is the Public Defense Summit we discussed on November 10th. So if you work in that realm and are interested in attending, please go ahead and register and let us know. In addition, for the in-person summit on December 16, please let me know if you're interested in attending. That is a limited capacity event, so we haven't publicized it to the general public, but please let me know. You can shoot me an email directly. So we're excited to have people come to that in Washington, D.C. I think I have covered most of the upcoming events, but most importantly, please stay tuned to that webpage, and thank you all so much. Check out the materials you all received for this program. If I missed anybody, I apologize, but thank you to everyone for making this an excellent program. And we will see you all soon. Thank you.